Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Be seated.
Good morning. Glad everybody made it here through the monsoon. Call the first case, please.
Dr. David Bruce Coffey versus Buckeye Home Health Center, Inc.
We'll hear from the appellant.
Good morning, Your Honors. My name is Ashley Beer Vineyard of the Knoxville Bar.
Good morning.
Morning. Presenting oral arguments this morning on behalf of the appellant, Dr. David Bruce Coffey.
Would you pull the microphone down just a little bit?
Yes.
Thank you.
Is that better? Okay.
Yes.
I'd like to reserve 3 minutes for rebuttal, please.
That'll be fine.
I'll begin my argument by briefly restating the relevant facts in this case. The appellant owned approximately 22,000 square foot commercial building in Oneida, Tennessee. In May of 2019, he entered into a lease agreement with the Appellee to lease an 1,800 square foot unit of that building. The lease between the parties obligated the Appellee to obtain fire insurance on the premises. However, the lease did not explicitly define the space to be occupied by or to be encompassed by the term premises. However, the lease agreement did utilize the term premises throughout the various terms of the lease. Each time it mentioned the term premises, it was referring to that portion of the building leased to the Appellee. The Appellee and the appellant are in agreement that the lease utilizes the term premises to refer to that 1,800 square foot portion. The Appellee immediately gained possession of the premises after execution of the lease, occupied the premises for 8 months. After 8 months, a fire occurred, destroying it. The appellant became aware that the Appellee did not have fire insurance and sued the Appellee for breach of contract. The trial court, in error, granted summary judgment in favor of the Appellee on the grounds that appellant's failure to define the term premises rendered the lease agreement unenforceable. This was an error for multiple reasons. First, the lease agreement is sufficiently definite to create an enforceable obligation. Second, if the lease agreement was deemed ambiguous or uncertain, the court is still obligated to attempt to ascertain the court's intent or the party's intentions in entering the lease. The lease agreement, despite lacking a definition for the term premises, utilizes the term throughout the various provisions of the lease, including on page 42 of the record under operation of business, where it states the tenant agrees to occupy the entire premises, indicating that the parties intended the term premises to mean that suite rather than the entire building. The Appellee has asserted that the appellant has asked his court to ascertain the intentions of the parties without providing proper guidance. The appellant would counter that argument by saying, in order to adopt the Appellee's position that the insurance provision is not sufficiently definite to create an enforceable obligation, one would have to ignore the various other provisions of the lease which utilize the term, and considering the lease in whole, there's really only one reasonable interpretation for the term premises, and that is that 1,800 square foot portion. Additionally, had the trial court determined the lease to be uncertain or ambiguous, nevertheless, they are still obligated to attempt to ascertain the parties' intentions, and they may do that by utilizing certain extrinsic evidence, including the parties' actions in carrying out the terms of the lease. Considering the fact that Appellee immediately gained possession, continued to occupy, and run its business out of the premises for 8 months, it's clear that the appellant and Appellee were aware of that space in which they were contracting to lease.
Excuse me for interrupting, counsel. I'm sorry. Go ahead, Judge.
Am I correct? Did I see in the lease where there was an obligation to present the landlord with the insurance documentation showing that they were a beneficiary on the coverage prior to entering into possession?
This was an obligation lease. The lease also did contain a non-waiver provision stating that landlord's failure to enforce any one obligation wouldn't waive Appellee's or his right to enforce any other. So we would submit that though they
did not require that lease be followed to that extent of the presentation showing documentation that they had the coverage before they entered possession?
I think I'm a little bit confused on the question there, Your Honor.
What I'm saying is, was the landlord entitled to see the fire insurance coverage or the policy coverage prior to the tenant going in possession?
He wasn't entitled to proof of insurance prior to occupation.
He was?
I believe he was, yes, Your Honor.
Okay. Then was that done?
I don't believe that's part of the record, but I don't believe it was. I'm sorry, was there another question?
Yes, as I understand, under the order granting summary judgment, the office space had an address designation of 277 Underpass, Oneida, Tennessee. Was that the 1,800 square feet, or was that the address for the entire building?
So the address for the entire building differed depending on which suite you were looking at. So
the suite, which constitutes the premises, is that correct? With this,
correct.
Was that assigned the 277 Underpass Drive, Oneida, Tennessee?
I believe it was, Your Honor.
The lease does not specifically address that address, is that correct?
I believe it does not, Your Honor.
Does the lease incorporate any other documents by reference in terms of a layout for the leased premises or any other reference to where the suite's located?
I believe the lease mentions an exhibit, but there is no exhibit to the lease.
I'm sorry.
I would have to double check the first page of the lease, but I believe there was an exhibit reference to that was never actually produced or attached.
So there was a reference to an exhibit, but that's not in the record, is that correct?
Yes, and it wasn't ever presented, my belief, to the
Thank you.
Appellee.
Yeah, my turn. Did the lease set out the square footage or anything like that?
The lease did not set out the specific square footage.
And the only basis for the trial court's determination, correct me if I'm wrong, is that premises was not sufficiently defined.
I believe the exact holding was that the appellant's failure to define the term premises in the lease renders the requirement that Appellee obtain insurance on the premises unenforceable. And that was the only holding that was. The Appellee in this case has presented an additional basis for which he's asked this court to affirm summary judgment, being that performance under the lease was impossible. The only evidence produced by the Appellee in support of this argument would be the affidavit of Derek Wurst, who was their insurance agent, who testified in an affidavit that insurance on a portion of the building would not have been obtainable in this case because the premises was not condominium. He also said that the Appellee has no insurable interest in the leased premises. We'd present to this court that the Appellee did have an insurable interest, and it was in my brief, but I will summarize here.
Excuse me, does the record show whether or not your client had insurance, fire insurance on the entire building?
It does not.
We don't know one way or another?
Okay. No, for the record, yeah.
Okay.
This court has previously held that one has an insurable interest, regardless of ownership. If by its continued existence it will gain some advantage, we assert that the Appellee had an insurable interest as a tenant leasing from an owner, and that the case law supports that. The Appellee has asked us to disregard the affidavit of the insurance expert, which was filed on behalf of the plaintiff at the trial level. He cites two cases, Fowler v. Happy Goodman and the Yatter case. Both affidavits in those cases are distinguishable from the affidavit in this case. In Happy Goodman, the affidavit was made solely on subjective belief. And in the Yatter case, the affidavit made certain presumptions. In this case, we have an affidavit from an insurance agent stating, first, that the insurance was obtainable, and that was his professional opinion based off his 16 years experience as an insurance agent, and then also that his agency could have obtained that insurance, which he did speak with multiple underwriters, which he testified to in his deposition testimony. Unlike the affidavits in the case cited by Appellee, Mr. Daniels testified that he was duly informed of the size and scope of the commercial property, as well as the portion leased to the Appellee. And that it was based off this information and the type of insurance required by the lease, his opinion based on his 16 years of experience that such insurance was obtainable. Considering this, it's clear that at the very least, there's a material or genuine dispute of material fact related to whether the insurance was obtainable. So this alternative basis is also an inappropriate grounds in which to affirm summary judgment. Having established that the lease uses the term premises to refer to the 1,800 square foot portion leased to the Appellee, that the Appellee and the appellant at the time of contracting were aware of what space they were leasing, and that at the very least there's a material genuine dispute of fact related to the impossibility argument, we would ask this court to reverse the trial court's judgment, ruling on summary judgment, and remand to the trial court. And if there's no further questions, I would yield the rest of my time.
I hear none, and you have your time for rebuttal.
Thank you.
Hear from the Appellee.
Good morning, members of the court. I'm Dudley Taylor from the Knoxville Bar. Just remember a time when I used to be younger than most of the judges I've faced. Now I'm older than all the judges I've faced. This is before the court on summary judgment. As you know, the trial court judge, Judge McAfee, held in favor of the defendant that without a definition of premises in the lease, that this could not be enforced. He did not take up our alternate argument, which was that even if the premises had been defined, it would be impossible to procure fire insurance for whatever that definition was. If the definition was the part of the building actually used by the defendant, then they would not be able to obtain fire insurance just for a portion of the building. I think you asked if there was an attachment or if there was a definition in the lease of square footage. There was not, but we, through discovery, determined that the square footage used by the defendant was about 1,800 square feet. There was about 22,000 square feet in the entire building. The normal way that would be done, as any transactional lawyer would know, and probably any lawyer would know, would be to impose a burden on the tenants, but with the landlord procuring the lease, and then it would be allocated as a part of a typical net lease where the tenants all share in the cost of the real estate taxes and the insurance and the common area maintenance. They didn't do this. I've never seen this in 60 years of practice, but again, there was the attempt to impose the burden to obtain the fire insurance on this tenant. Again, getting beyond the issue, the legal issue of construction of the contract on what was required, there is the issue of the impossibility of obtaining fire insurance on a portion of the building. It just can't be done. It can be done if there's a condo because you have separate ownership. And if it was the entire building, it could not, the tenant would not have an insurable interest in anything except what he was actually occupying. And that is in the record throughout.
The term tenant, wasn't that used to refer to the actual part of the building that he would be occupying, the tenant would occupy?
If that was the actual premises and had been defined, it would have been impossible to obtain fire insurance on that portion, just a portion of a building. And if it was the entire building, then our expert stated that the tenant would not have an insurable interest in anything other than what that tenant was actually occupying and using. Again, the trial judge did not really make any reference to that. We discussed it, but he ruled specifically on the issue of it can't be enforced if there's no definition in the lease itself. And I would like to point out one thing to the court too, that the plaintiff introduced the deposition, an affidavit of their own expert. He was a young man, very nice young man, worked in the insurance business, had no qualifications and so forth. But one of the first questions that I asked him was to, was to provide him with a copy of the lease and ask him if that was sufficient information, would provide him sufficient information to procure insurance, fire insurance. He said he could not. That's on page, let's see, 180. Sorry, my eyes have slipped away. Yes, page 188 in the record. This Mr. Daniels said that there was not enough information in the lease to allow him to obtain a policy including fire insurance coverage. So, Your Honor, our point is that we think the trial judge is right on that issue of legal construction of the contract, but beyond that, then we would have a defense that should be honored by the court, and that it would not be possible to obtain fire insurance on either that 1,800 square feet obtained or on the entire building because of a lack of insurable interest. And with that,
Did the plaintiff's experts say, I understand what you're saying, that he, in response to your question, he said there's not enough there in the lease for me to tell, but did he say that it couldn't be obtained? In other words, got information from other places.
I'm sorry, our expert said it could not be.
I know your expert did, but what about theirs?
Their expert said it could, Your Honor. He initially said that he had written insurance for a tenant on a portion of a building, and then he backtracked and said, no, I have not. The one that I wrote, it could be.
But this was summary judgment is where it went off on.
Yes, Your Honor.
Okay.
Was it ever an attempt by the tenant to obtain insurance on the premises that was as referred to in the lease?
They had insurance on the personal property inside that space they occupied. Is that what you said, Your Honor?
Okay.
What you asked
You
about?
had coverage on that, okay. But what about, according to the lease, insurance on the premises that was being leased? Was there ever any attempt to obtain insurance on those premises?
Well, again, pardon me if I'm missing the point of your question, but there was no definition as to what was to be occupied. Now, it's obvious that the parties knew outside the lease because they had a specific portion that they did physically occupy. So in terms of having the occupancy defined by premises, they did that kind of after the fact. I think there was a point made in the brief of the appellant that there were really two leases. There was a written lease, and then it was supplemented by an oral lease, and I think that the meaning of that was that they knew what they were going to actually occupy and what they did not. But again, our argument was that, one, no definition. Two, even if you agreed that the definition was spelled out in the lease and it was just 1,800 square feet, they would not be able to obtain fire insurance on that part of the building because it was simply part of a building. That was my point, intended point.
I mean, there's no dispute that both parties knew what I understand what you're saying about the lease didn't define it.
Yes, Your
but both parties knew what the premises were. I mean, your client occupied them.
Yes, Your Honor.
He didn't show up there befuddled as to where he was supposed to move his furniture in or anything, did he?
Yes. There's no dispute about what was actually occupied. The dispute would
and he obtained insurance on the furniture and the contents in that part that he occupied.
Yes, Your Honor.
He didn't obtain insurance on the furniture or furnishings outside the part he occupied.
Right. That's exactly right. And again, I think, although I don't think that Judge McAfee actually spelled it out right exactly like this, but I inferred from the discussion and what we put down that even though they may have agreed as to what premises would have been in terms of what they were actually going to occupy and use, there was no definition to allow the word premises to be applied to the requirement of fire insurance. And again, I don't want to keep repeating myself, but then you got the issue of, is it just the 1,800 square feet, which can't be done since it's a part of a building, or is it the entire building? I mean, there's a lot to, I guess, to dig into in terms of what insurance may have been carried by other parties. That's not in the record, so obviously I won't offer that, but we've done some looking into that too. So again, I would close with just the request that the court affirm the judgment and that there are no undisputed material facts, and the defendant's entitled to judgment as a matter of law. Ask any other questions? Thank you. I appreciate your attention.
Thank you, counsel. We'll hear from the appellant rebuttal.
Just to make a few quick points here in rebuttal. The appellee mentioned that Chad Daniels, our insurance expert, had mentioned in his deposition testimony that the lease did not contain enough detail to actually obtain a policy. We'd assert to this court that in order for the lease to be enforceable, it merely would just have to be definite enough to alert Appellee that they had to obtain insurance. And if they needed to get specific square footage or any of this information, this could have been obtained afterwards. But even without this information, the lease is sufficiently definite to create an obligation to obtain insurance. Further, just to kind of summarize our argument here, I know I've briefed them, but this is not a case where you have a contract that is so uncertain and so lacking in terms that it is proper for a court to determine that there's no enforceable obligation here. The court is obligated to review every provision of the lease in which is contained in the lease, and all of which mention the term premises, almost every single one. And there's only one reasonable interpretation, and the parties are in agreement. So we'd assert to this court that at the very least there's a material dispute of fact, making it inappropriate that the trial court granted summary judgment, and we'd ask this court to reverse the trial court's decision. Thank you.
Court's thanks to counsel for both sides. We appreciate your arguments and your brief today. We'll take the case under advisement and let you